Namaste. We were in the third chapter of the Mediation Act 2023 and we discussed about the mediation agreement, pre-litigation mediation, and in this session we will discuss on Section 6 of the Mediation Act, disputes or matters not fit for mediation. The Act outlines specific types of disputes that are not suitable for mediation. This section and the first schedule of the Mediation Act details the exclusion, ensuring the clarity on which matters that cannot be resolved through mediation. So mediation is not to be conducted for dispute or matters that are listed in first schedule. This includes various types of disputes deemed inappropriate for mediation due to their nature or legal stipulations. So court retains the discretion to refer the disputes related to the compoundable offences, including certain matrimonial offences, to mediation. If deemed appropriate, the courts can refer. However, the outcome of such mediation do not constitute a judgment or decree, but must be considered further by the court according to the current law. This ensures the judicial oversight and compliance with the legal standard. This section also enumerates that the central government holds the authority to amend the first schedule through notification if deemed necessary or expedient. This allows for the flexibility and update to the exclusion list as required by the changing legal and social circumstances. So the first schedule is an indicative, as the central government has the power to amend this first schedule and include even more number of matters, or it can even reduce the number of matters that can be referred for mediation or not referred for mediation. The first schedule, that is the disputes not fit for mediation. Firstly, the dispute that cannot be mediated as per the existing laws, that is the disputes wherein some of the dispute that are been avoided by the existing laws or that cannot be submitted by law. The disputes involving minors, deities, individuals with intellectual disabilities as per the Rights of Persons with Disabilities Act 2016 and Mental Healthcare Act of 2017 and of unsound mind. These includes those proceedings under Order 32 of the Civil Procedure Code 1908 and the suit for declaration of title against the government can also be not referred for mediation. As we all know, criminal offences cannot be referred for mediation. Yes, even the first schedule also includes that criminal offences cannot be resolved through mediation. Disputes involving criminal prosecution are excluded to ensure the criminal justice process are not bypassed. Professional misconduct, the complaints or proceedings related to the registration, discipline, misconduct of a professional regulated under various laws, that is legal profession, medical professionalist, dental professionalist, architectural, accounting. So these are the various professionals which are been recognized under various laws, and if any complaints relating to their registration, discipline or misconduct of their professional shall not be resolved through mediation. So disputes affecting the rights of a third parties not involve mediation except in matrimonial disputes where a child's interest is considered. Matters falling under the jurisdiction of a national green tribunal, that is, we call it as an environmental jurisdiction. Disputes relating to levy, collection, penalties, or offences concerning to direct or indirect taxes or refunds, that we call it as a tax-related disputes. The proceedings under the Competition Act of 2002 or Telecom Regulatory Authority of India Act of 1997 and related authorities, because there is a separate authority that has been established to resolve such disputes and wherein investigation is required, because Competition Act, Telecom Regulatory Act, there is a strict investigation is required with respect to such disputes. So hence that cannot be resolved through mediation. The dispute in the electrical sector, the proceedings before the appellate tribunal for electricity and related commissions under the Electricity Act of 2003. So that should not be referred for mediation. Petroleum and natural gases. Proceedings before the Petroleum and Natural Gas Regulatory Board and related appeals shall not be referred to mediation. The proceedings before the Securities and Exchange Board of India under the SEBI Act of 1992, that is, the disputes relating to land acquisition, even compensation, determination relating to land acquisition should not be referred for mediation. All these disputes cannot be referred for mediation. Further, as I told earlier, like this is an indicative, the list of indicative, because another provision that has been included in the first schedule, that is any other dispute specified by the central government can also be referred for mediation. So the central government has the power by means of section 6 as well as by means of first schedule, has the power to include additional matters that are not fit for mediation. The exclusion for the mediation under this act are designed to ensure that the mediation is used appropriately and does not interfere with the process that require judicial or statutory oversight. By clearly outlining these exclusions, the Act provides a clear framework for appropriate use of mediation, safeguarding the interest of vulnerable parties, maintaining the integrity of professionals and regulatory proceedings, and ensuring that the criminal and environmental matters are handled through the proper legal channels. So these exclusions is essential to be understood for all of us, that is including the legal professions and the parties, to recognize the boundaries within which the mediation can be effectively utilized. With this, we conclude over here with respect to section 6. Thank you.